Florida has now become the 5th state in the U.S. to enact community property trust legislation. A married couple may now establish community property in Florida. Okay, so why should you care about being able to establish community property? Well, community property is subject to a special tax basis adjustment rule. On the death of this first spouse, all of the appreciated property will receive a new basis equal to fair market value. This is known as the double step-up. For example, let's suppose the married couple owns property with a basis of $2 million and a value of $4 million. On the death of the first spouse, the basis will be adjusted upward to $3 million. However, if that same property had been community property, on the death of the first spouse, the basis would have been adjusted upward to $4 million. As a result, in our example, the surviving spouse would have avoided an additional $1 million capital gain income. It's important to keep in mind that the tax benefits of a Florida community property trust are not certain. There are no IRS rulings, cases, or pronouncements confirming that community property established under the new act will be respected by the IRS for income tax purposes. Also, it's important to keep in mind that tax is not the only consideration. For couples transferring property to a community property trust, they may be changing their rights to that property during the marriage and in the event of death or divorce. Also, property owned by a Florida community property trust may be more exposed to creditor claims than other forms of joint ownership, like tenancy by the entirety of property. A Florida community property trust won't be the right fit for every couple. However, in the right situation, a community property trust can save significant income taxes.